Let's get right to the heart of this. The defendant, your former landlord, is holding your security deposit. You claim that not only did she keep that money, but she took it upon herself to dispose of your personal property without your consent. Is that your testimony? Yes, that is exactly what happened. And the defendant claims that you never provided the mandatory 30-day notice for your lease termination. She also asserts that you left the property in a state of disrepair that far exceeded the coverage of your security deposit. That is the basis of her counterclaim. I want the facts. How long were you residing in this property? Approximately 18 months. Was this a private house? Yes. I want a clear, honest answer. Who exactly was living in that home? I want a clear breakdown. It was myself, my 3 children, my grandson, and a roommate. Who was this roommate? It was my nephew. He's been a longtime family friend for years. Was he paying rent to live there? He was paying $400 a month. Don't stop there. Who else was in that house? I have a feeling there is more to this story than you are letting on. Well, 6 months after we moved in, my grandson's father moved in with us from California. Let me make sure I have this right. You, 3 children, your grandson, a roommate, and then the grandson's father moved in on top of that? That is a house full of people. Yes, that is what happened. And how much was the grandson's father paying to reside there? He paid $400, just like everyone else. Let's do the math. If the total rent for the home was $950, and you have 2 people paying $400 each, that is $800 total. That means your personal contribution for the rent for you, your 3 children, and your grandson was a measly $150? Do you really expect me to believe that? We had bills to cover. Their rent included the utilities, the cable, the internet, the water, the trash service, and the electricity. Do you have a copy of the lease agreement? I want to see exactly what you put your signature on. When precisely did your grandson move in? He came with us from California in June of 2013, along with the rest of the family. The lease specifically mentions 3 children. Which 3 is the document referring to? She wrote 3, but 4 children actually moved in with us. I consider my 2 4-year-old daughter to be my child. An adult is an adult, regardless of whether she is your daughter. That is an extra adult living in the home that was not properly accounted for. You had an extra person occupying that property. This tells me you were playing fast and loose with the terms of your lease from the very beginning. I want to know exactly what you think you were entitled to when you vacated that premises. Tell me, what was the total security deposit involved here? It was $300. And you held on to that money because of damages, correct? What exactly did you do to the property to justify that? We took all the trash out. We treated the carpets with enzymes because of the pet damage. We had to replace the cracked glass and the screens. I want to see the proof. Give me the photographs you have. Yes, ma'am. I also have my own photographs of the house, too. When were these taken? Were they taken when she moved out? Yes, ma'am. I am looking at these now, thank you. This just looks like standard cleanup to me. It is not structural damage. Yes, Your Honor. Whatever. If that is all that was there, that is just basic cleanup. And you managed to re-rent the house within a single month, didn't you? Yes. So, you didn't suffer any actual financial damage, did you? You weren't left without a tenant. You lost no rent. What is the justification for keeping her deposit? We weren't able to finish cleaning up properly because she came and changed the locks before the month of November was even over. We couldn't finish moving our things or cleaning the house because we were barred from entry. Your Honor, the reason I had to go through the window to get into my home, a home I own, is because all the locks were changed on me. Stop. November 30th. That was the end of the term. You didn't own the right to be in that house until November 30th had passed. What day did you go in there to change those locks? November the 20th. You cannot go into a property you have rented out on November 20th and change the locks. You had no right to be there until the lease concluded on the 30th. You were in the wrong. You took the law into your own hands. You cannot unilaterally decide that a lease is over because you are angry. You are a landlord, not a dictator. Did you have a court order to enter that property on the 20th? No, Your Honor. Exactly. You didn't. You decided you were the judge, the jury, and the executioner, and that is why you are standing in my courtroom today. You keep complaining about her not giving notice, but you violated her right to quiet enjoyment of the premises. That is a fundamental breach of contract. Do you understand what a breach of contract is? She shouldn't have had all those people there in the first place. It was in the lease. Whether she had an army living there is irrelevant to your obligation to follow the law. You cannot evict people by changing the locks. You cannot treat a tenant like a trespasser just because you are frustrated with their behavior. This is a court of law, not the Wild West. You don't just change locks because you're angry. You follow the eviction process. Did you file an eviction? Did you go through the court? No, I didn't. You didn't want to cause trouble, or you knew you were already in violation of your lease for having an unauthorized roommate and an extra adult living there? It sounds to me like you knew you didn't have a leg to stand on, so you didn't involve the police. That is a very convenient choice for someone who claims their rights were being violated. I am done listening to excuses about the locks. I want to know exactly what you think you were entitled to when you vacated that premises. So, you admitted it. You changed the locks on November 20th, while the lease was still in full force and effect until the 30th. Did you have a court order? Did you have a writ of possession? Did you have any legal authority to lock these people out? No, Your Honor, but the house was a disaster. I was afraid they were going to do more damage. That is not your choice to make. You do not get to determine when a contract is over just because you are angry. You do not get to play law enforcement. You are a landlord, not a sovereign ruler. You signed a contract. You agreed to let them live there until November 30th. By changing those locks 10 days early, you committed an illegal lockout. Do you have any idea how much trouble you could be in for that? I was just trying to protect my property. You protect your property by filing an eviction with the court, not by taking the law into your own hands. You don't have the right to deprive your tenants of their home. If she wanted to move her things out, she had the right to be there to do it. You denied her that right. You are lucky she didn't call the police, because you would be standing in a different kind of court right now. But the damages, I am not interested in the damages right now. I am interested in the fact that you violated the law. And let's talk about the pictures again. You claimed the place was destroyed. I see these photos. This is not destroyed. This is a mess, yes, but it is not a reason to withhold a security deposit. You have no justification for keeping her $300, and you certainly have no justification for the way you handled this eviction. You acted in bad faith. I just wanted them out. They weren't supposed to be there. The terms of the lease are what they are. If they breach the lease, you take them to court. You don't get to act like a vigilante. Is there any reason you shouldn't return this money immediately? I think I should be compensated for the cleanup. You are not getting a dime for cleanup beyond what is reasonable, and frankly, I don't think you deserve anything for it. You acted illegally by changing those locks. That is a strike against your credibility in this courtroom today. Do you have any other evidence regarding the condition of the house? Because so far, everything you have presented to me is just your word against hers, and your word is currently tied to an illegal lockout. I have receipts for the cleaning supplies. I don't care about the receipts for the cleaning supplies. That is the cost of doing business as a landlord. When a tenant moves out, you clean the house. You don't charge the tenant for the fact that you have to sweep the floor and wipe the counters. That is a pathetic attempt to squeeze money out of someone. I have heard enough about the damages. Let's discuss the property condition in more detail. You said there was pet damage to the carpets. How many pets were in the house exactly? There were 2 dogs. And what kind of condition were they kept in? Were they housebroken? They were not. There was urine on the carpets, stains, everything. And how many of you were living there to supervise these animals? There were 5 of us, plus the children. 5 adults living in a house with 2 untrained dogs, and you are surprised there was a smell? That is what happens when you cram that many people into a home with animals. That is not the tenant's fault. That is the reality of your rental situation. You knew how many people were there. You knew there were animals. You accepted the rent. Now you want to penalize her for the inevitable consequences of the living arrangement you allowed. You're telling me that 5 adults and all those children and animals were living in this house, yet you never once conducted a formal, documented inspection? You never walked through the property with the tenant? You never signed off on the condition of the carpets at move-in? You just took the keys back and decided on your own to keep the money? That is not how a responsible landlord operates, and you know it. I was busy, Your Honor. I trusted them to take care of it. You weren't busy. You were negligent. And then, when you realized your own lack of oversight, you decided to compensate for your negligence by changing the locks illegally. When you changed those locks on the 20th of November, you made a very big mistake. You committed an illegal lockout, plain and simple. Did you have any legal authority, any court order, or any writ of possession to prevent your tenant from entering the property they were paying for through the end of the month? I was just trying to protect my house. I didn't want them to do anything else to it. You don't protect a house by breaking the law. You protect a house by adhering to the lease agreement and following due process. How much do you think you're actually entitled to keep from this woman's deposit? Be honest, because I'm looking at your claims and they are completely unsubstantiated. I think I should keep the $300, plus the additional costs for the professional cleaning and repairs. The $300 is hers. It was never yours to keep in the first place because you failed to perform a proper move-out inspection. You cannot charge for cleaning without proving with concrete evidence that the condition of the home was significantly worse than when they moved in. And quite frankly, after hearing your testimony today, I don't trust a single word you've said about the condition of that property. You are grasping at straws to justify an illegal act, but the screens were ripped and the carpet was ruined. It smelled like animals. Screens are wear and tear. Carpet stains from animals are debatable. But again, you didn't document their condition at the move-in. You want to be a landlord? You play by the rules of the contract. You didn't. You acted like a bully who decided that because you owned the building, you owned the lives of the people inside it. That is not how it works. They shouldn't have moved all those people in without telling me. It was in the lease. Whether she had an army living there or just one person is irrelevant to your legal obligation to follow the law regarding evictions. You cannot evict people by changing the locks. You cannot treat a tenant like a trespasser just because you are frustrated with their behavior. This is a court of law, not the Wild West. You don't just change locks because you're angry. You follow the eviction process. Did you file an eviction? Did you go through the court? No, I didn't. Exactly. You didn't. You decided you were the judge, the jury, and the executioner. You bypassed the legal system because you thought you could get away with it. And that is why you are standing in my courtroom today. You keep complaining about her not giving notice, but you violated her right to quiet enjoyment of the premises. That is a fundamental breach of contract. Do you understand the severity of what you did? I just wanted them out. They weren't supposed to be there, and I was losing money every day. The terms of the lease are what they are. If they breach the lease, you take them to court. You don't get to act like a vigilante. Is there any reason you shouldn't return this money immediately? I should be compensated for the work I had to put in. You are not getting a dime for cleanup beyond what is reasonable, and quite frankly, I don't think you deserve anything for it. You acted illegally by changing those locks. That is a massive strike against your credibility in this courtroom today. Do you have any other evidence regarding the condition of the house? Because so far, everything you have presented to me is just your word against hers, and your word is currently tied to an illegal lockout. I have receipts for the cleaning supplies I bought. I don't care about the receipts for the cleaning supplies. That is the cost of doing business as a landlord. When a tenant moves out, you clean the house. You don't charge the tenant for the fact that you have to sweep the floor and wipe the counters. That is a pathetic attempt to squeeze money out of someone. I have heard enough about the damages. You are not a victim here, and you are certainly not the aggrieved party. You are a landlord who failed to do your job and then broke the law when things didn't go your way. Show me the move-in inspection report, the document that states the condition of the carpet, the walls, the windows, and the screens, the day she took possession of the house. Where is it? I didn't think I needed one. We did a walkthrough, but I didn't write anything down. You didn't think you needed one? You are running a rental business. You are dealing with people's money and their livelihood. And you didn't document the condition of the property? That is the most basic responsibility of a landlord. How are you expecting me to believe that the damage you're claiming this so-called disaster was caused by her and wasn't already there when she moved in? I just know it wasn't like that before. I took pride in that house. You took pride in it, but you couldn't take 5 minutes to fill out a checklist? That is not pride. That is laziness. And now you're standing there trying to pin a cleanup bill on a tenant because you were too lazy to do your job as a landlord. How do you respond to the claim that the carpets were treated for pet damage? Your Honor, we had the carpets cleaned when we left. They weren't ruined. They were used, yes, but they weren't destroyed. The landlord is just trying to get us to pay for new flooring on her terms. Let me see that carpet cleaning receipt. This is what I'm talking about. A professional cleaning receipt. That is evidence. That is how you prove you left the place in a reasonable condition. Unlike you, landlord, she has proof. You have nothing but your word. And so far, your word has been tied to an illegal lockout. That puts you in a very difficult position. But the smell of the urine, it was unbearable. I'm not interested in your dramatic descriptions of smells. I'm interested in whether or not this was normal wear and tear for a house occupied by 5 people and 2 dogs for a year and a half. Of course, there is going to be wear. You accepted that risk when you took the rent money. You don't get to demand a brand new house when they move out. You are not running a luxury hotel. You are running a rental home. I just want to be compensated for the work I had to do. And I want you to be held accountable for the law you broke. We aren't done here yet. I want to know about the belongings you supposedly disposed of. You said you didn't throw anything away, but she says otherwise. Let's talk about those items. What exactly was removed from the property, and how do you justify entering that home before the lease was officially terminated? I had to get in because I was worried about the pipes. I heard water running. Water running? You're changing your story now? First, it was trash, then it was pets. Now you're telling me you were a plumber? You don't get to invent emergencies to justify a breach of contract. Did you call the tenant to tell them you heard water running? Did you ask them to meet you there? No, I didn't. I just went in. You just went in. You have a pattern here of ignoring the law when it suits you. You decided you were the boss, you decided the lease was over, and you decided you could bypass the law. That is a dangerous way to operate a business. I want to see exactly what you claim she left behind that was worth throwing away. If you can't prove it was trash, you are going to be paying for every single item. So, let me get this straight. You walked into a property that you still had under lease, and because you heard running water, you decided to change the locks? That is called a self-help eviction, and in most jurisdictions, it is against the law. You can be sued for that. You didn't call the tenant, you didn't call the police, you just decided to take over the property. Is that correct? I was afraid of the damage. The water bill would have been astronomical. You are a landlord. You accepted the risk of the property when you rented it out. You do not get to panic and break the law because you are worried about a utility bill. Did you ever receive a massive water bill? Not yet, but I was sure it was going to happen. So you acted based on a hypothetical water bill? That is the most ridiculous justification I have heard all day. You breached the contract because you were afraid of a maybe. You, as a property owner, have a fiduciary responsibility to act within the confines of the law. You are supposed to be the responsible party in this relationship, and yet, here you are, acting like a child who didn't get their way. The tenant was disrespectful. She had all those people living there. The number of people living there is a separate issue from an illegal lockout. If she violated the lease with extra tenants, you file an eviction notice, you go to court, you get a judge's order, and then you have the sheriff remove them. You do not just show up and change the locks. You are lucky she didn't call the police on the spot, because you would have been the one in cuffs. Do you have any idea how much liability you've opened yourself up to? I didn't think it was that serious. That is the problem. You didn't think. You reacted. And that is why you are standing in my courtroom, and that is why you are going to be held accountable. You are not a victim of a bad tenant. You are a victim of your own poor judgment and your complete disregard for the legal system. Let's talk about the items you allegedly disposed of. She says you threw away her belongings. What do you have to say about that? I didn't throw away anything of value. It was just trash. Bags of old, ripped clothes and broken toys. Trash is a very subjective term. When you take the law into your own hands and decide what is trash and what isn't, you are stealing. You have no right to determine the value of someone else's property, even if they are in breach of a lease. Where are those items now? I took them to the dump. You took them to the dump? So, you made it impossible for her to prove the value of those items? That is the definition of destroying evidence. You have put yourself in an incredibly precarious position. You are here in my court with no inspection report, no proof of damages other than your own word, an admission of an illegal lockout, and an admission that you destroyed the items the tenant is claiming. Do you understand how this is going to end for you? I just want to be compensated. You are not going to be compensated for a disaster you created yourself. You want to talk about compensation? We should be talking about the damages you owe her for the illegal lockout and the destruction of her personal property. You think you're smart, but you've just laid out a case against yourself. You sit there and try to justify illegal behavior with excuses about protecting your investment. Let me explain something to you. When you enter a contract, you give up a certain amount of control. You cannot bypass the law just because you feel a situation is unfair. You chose to be a landlord. That comes with specific legal obligations. One of those obligations is to respect the privacy and the legal possession of your tenant until the day the lease is officially terminated. You failed to do that. You made yourself a trespasser on your own property. And now, you have the audacity to come into my courtroom and ask for money for cleaning? You testified that you re-rented the place in December. If the house was such a disaster, if it was truly trashed, you would not have had it ready for a new family in a matter of weeks. You are not being truthful with me. You saw an opportunity to keep $300. You saw an opportunity to get rid of a tenant you didn't like, and you took it. You didn't do it out of necessity. You did it out of arrogance. You thought you could push this woman around because you owned the building? Well, in my courtroom, ownership does not give you a license to ignore the law. I am finding for the plaintiff. You are ordered to return the $300 in full, immediately. You have no legal basis to withhold a single cent of that money. Your counterclaim is completely unsubstantiated, and it is dismissed with prejudice. I don't want to hear another word about cleaning supplies or so-called trash. You have failed to prove any damages that go beyond normal wear and tear. You have failed to produce a single shred of evidence that justifies your actions. You are a bad landlord. You are an inexperienced business person, and you have lost this case. Do you understand? You are not to contact Miss Sims again. You are not to attempt to collect any further funds from her. Consider this your lesson in property law. Next time, if you have a problem with a tenant, you file the paperwork like everyone else. You do not climb through windows. You do not change locks. You act like a professional, or you stop being a landlord. You are lucky she didn't call the police on the day of the illegal lockout, because you could be facing criminal charges right now instead of just a judgment in a civil court. You have wasted my time, you have wasted the court's time, and you have humiliated yourself with your own admissions. You think you're smart for trying to outmaneuver your tenant, but all you've done is build a case against yourself. Take your judgment and get out of my courtroom. We are finished here. You came into this courtroom and tried to convince me that you were acting out of fear to protect your asset. You are not a victim of a bad tenant. You are a victim of your own incompetence and your total lack of respect for the law. Let's look at the reality of the situation. You allowed 5 adults and multiple children to live in that house. You took their money, you knew exactly who was there, and you looked the other way as long as the rent checks cleared. Then, when it became inconvenient for you, you decided the law no longer applied. You don't get to be a landlord when the rent is coming in, and a vigilante when you want the property back. That is not how a civilized society operates, and it is certainly not how you operate in my court. You changed the locks on November 20th. The lease clearly stated it was in effect until the end of the month. That is a fact you admitted to under oath. You had no legal basis to evict them, no court order, and no justification for treating them like squatters. By taking matters into your own hands, you committed an illegal lockout. That is a tort. That is a violation of the civil code. You opened yourself up to a massive lawsuit, and frankly, I am surprised the plaintiff didn't come after you for more than just the security deposit. As for your claims of damage, you have no move in inspection report. You have no proof of the condition of the house prior to their occupancy. You have nothing but your own opinion, which, based on the evidence presented today, is not worth the paper it's printed on. You claim the carpets were ruined, yet you had the house re-rented in less than 3 weeks. That is not a disaster area. That is a functioning rental property that you were simply too impatient to manage properly. You wanted to get rid of them, and you chose the illegal route to do it. I am ruling in favor of the plaintiff. You are ordered to return the full security deposit of $300 immediately. Your counterclaim for damages is denied in its entirety. It is baseless, it is unproven, and it is a waste of this court's resources. You are to pay the plaintiff, and you are to consider yourself lucky that she is not pursuing you for further damages. This should be a wake-up call for you. Being a landlord is a professional business, not a hobby you can manage with temper tantrums and illegal locks. You failed to follow the proper legal procedures for eviction, and that failure has cost you this case. Do not ever think that you can bypass the judicial system to suit your own schedule. If you ever have a dispute with a tenant again, you go to the courthouse, you file the proper paperwork, and you wait for a judge to give you the authority you think you already have. You have acted like an amateur, you have been treated like an amateur, and you have lost like an amateur. We are finished here.